Chairwoman, members of the committee. Thank you, Senator Metz, for your longtime support for this legislation and your leadership on this issue. My name is Amy Renault, and I'm representing Rhode Island Housing today. I am also bringing word of support, the strong support of the Public Housing Association of Rhode Island. Unfortunately, there is a public housing conference in Connecticut at which all of my companions in the public housing world are attending at the moment, but the Public Housing Association of Rhode Island has been a very strong supporter of this legislation, and we appreciate that as well. As Senator Metz so eloquently described in his introduction, Senate Bill 2134 would prohibit discrimination in housing based on a person's lawful source of income. I want to be clear that that can be rental assistance, but it could also be Social Security or veterans benefits or other sources, and that was an intentional decision because there are certainly folks, in addition to those with a rental assistance voucher, who face discrimination because of that source of income, and we wanted to make sure that their rights were also protected under this law. Rhode Island Housing is a public housing authority. We provide housing choice vouchers to about 1,500 folks, and there's another 8,000 vouchers that are administered by other public housing authorities. As Senator Metz mentioned, many of those people wait for years to get a housing voucher, and then many of them face the challenge of finding a landlord who will be willing to accept that voucher. And some of those folks lose their voucher, which is hard to believe that someone in that kind of a situation, very low income, wait years on a waiting list only to find that you can't find a place in the state where your voucher would be accepted. That's what this bill is meant to address. At Rhode Island Housing, we do an ongoing survey of our voucher recipients, and we've found that almost half of those voucher holders have had landlords specifically tell them that they would not consider them as a tenant, specifically because of their rental assistance voucher. I'm going to leave to Alex to talk about the research that South Coast has done about the incidence of source of income discrimination in the state. I will say that to remind folks that, first of all, there is nothing in this legislation that prevents landlords from denying a tenant based on the normal checks that they would do on a tenant. They can still do their background checks. They're talking to creditors or their previous landlords. They're still allowed to do all the steps that a landlord would take to make sure that they have a good tenant. They just can't say under this law, I'm not going to even consider you because you have a voucher. And I would just update Senator Metz. We're up to 14 states, I think possibly even more, but at least 14 states and 76 counties and municipalities that have adopted this type of legislation. Before I close, I'll just address a couple of, and Senator Bell, you had called me earlier, raised your concerns, and shared more detail. So I did check with our staff attorneys, and Alex shared with Alex over at the South Coast Fair Housing as well. I'll speak to a couple of elements that are more in our bucket, and I think Alex will speak to some that are more in his bucket. You didn't touch on it tonight as much, but in your when we spoke on the phone and in your email, you mentioned project-based Section 8. And so for folks who aren't familiar with that, there's tenant-based rental assistance that goes with the voucher holder, and there is project-based that is tied to a specific unit. And you had raised the concern about if this law passed, if market rate folks would be able to access those units. So did check in with our staff attorneys, and that would not be a risk. Federal law supersedes the state law. Also, because the subsidy is attached to the unit, not the person, there's not a source of income discrimination associated with that. And under the definitions in the law, a wage earning, wages from a job are not sort of a protected class under the language of this bill. So we don't believe that would be a concern. Also, you were mentioning code issues and concern around code issues. And there was language that was added to the bill last year, and I believe it was drawn from the Massachusetts law around and you touched on it, the program requirements language. And that was actually specifically added so that a landlord couldn't say something to the effect of, I'm fine with taking a Section 8 tenant, but I'm not willing to have my unit inspected or something like that. So that's why some other states, including I believe Massachusetts, have put that language in. And I would say that the code is state law. The requirements to have a voucher, the standards for an apartment are basically code. And we believe strongly that if you are a landlord in this state, you should be following the law. You should be meeting the code requirements of the law. And so don't consider it a burden for landlords to have to basically show that they are meeting the basic requirements of having a habitable unit by meeting the HQS, it's called. So anyway, those are just my response to those elements that are sort of more in our bucket. But I know Alex will speak to some of the others. That's all I had, but I'm happy to answer any questions that anybody has.
Thank you. Any questions or comments for Ms. Renault? Thank you very much.